to end this discussion on the intersections of these two, and it's really to have an intersectional discussion. And so I have the supreme pleasure of introducing our moderator today. But before I begin, I would like to just remind everybody of the house rules. Please do ensure that when you are not speaking, your camera and your mic are off. And please, can we just request that you speak slowly so that our interpreter who is online is able to interpret and has sufficient time to do that. And also just to remind everyone that interpretation services are available as well. And with that being said, I am Kyo, who is going to be giving the opening remarks and will be introducing the speakers as well. And just additionally to say that there is a live stream that is available for the afternoon session. And if you are willing to, you can go and check it out on the YouTube page. But really to say welcome to everybody for what promises to be a wonderful and an insightful discussion as well.
Thank you so much, Alma. I am here on behalf of my boss, Kajal Ramjathan Kio, who is the Africa Program Director here at the International Commission of Jurists. I just want to check quickly before I get into the opening remarks, facilitators, if there are people in the room. I know we started a little bit before 3:30, but we're now on 3:30 on the dot. If there are people in the waiting room, we'll just give them a second to get in before I get quickly.
We're admitting them as they come in, so you may continue doing the address. We will control them as they come in, so don't worry about that.
Fantastic. I appreciate it. Thank you so much. So as I mentioned, my name is Nokukanya Farize, but you can call me Kanyo. I am a legal advisor here at the International Commission of Jurists, Africa Regional Program. And I am just opening the session on behalf of Kajal Ramjathan Kio, as I mentioned, who is unwell, unfortunately, today. So thank you, Alma. As Alma has mentioned, we are in the Global South Symposium on ESCR and SOGIE, and we have over the past several hours been reflecting on evolving laws and jurisprudence in Africa. And so this session is really the grand finale, if you want to call it that. But if you've missed all the other sessions, this is really the one that you're doing very good by joining, because I think this is the one we've all been looking out for and one we've been building up towards over the past few hours. We started off yesterday really laying the groundwork, where we spoke about some of the advances that have been made on the continent insofar as litigation is concerned with respect to sexual orientation, gender identity, and expression. And then we looked at the pitfalls and some of the opportunities that exist for litigation. And I must tell you, the session that I was in, the breakout room, was really, really, really amazing. I don't know about the other one, but I also heard very good things about the parallel breakout session, which was focused on economic, social, and cultural rights. And there too, the groundwork was laid yesterday, where we spoke about the enforcement of economic, social, and cultural rights in Africa, looking at both the domestic level as well as the regional opportunities that exist. So this session therefore brings both those issues very much together, in as much as we had built over the past few hours. And we will speak in particular about poverty and transgressive sexuality in Africa, looking at what are the common connections of criminalization and discrimination. And as I mentioned, this is a very exciting panel. the speakers are really, really, really brilliant minds and thought leaders in this space. So I am very, very excited that we're going to hear from them in this panel. And I will just go through our panelists. I'll start with Ms. Annika Mirkota. Annika is the current executive director of the Southern African Litigation Center. She has specialized in public interest litigation and advocacy on gender-based violence, sex worker rights, rights of people living with HIV, sexual and reproductive rights, access to justice, and child justice. She previously worked as an attorney at Swaranang Legal Advocacy Center and the AIDS Law Project. I'm sure Annika will tell you more about her and about her work, but the reputation of SALC definitely precedes them. So I'm sure everybody in the room is really looking forward to hearing their contribution. And then we also have moderating Dr. Satang Nabane Cham. I hope I've said that correctly. If I haven't, I apologize. Dr. Satang is a socio-legal scholar, researcher, consultant, and human rights lawyer from the Gambia. Dr. Satang is currently working with the Center for Human Rights. Her teaching and research focus on international human rights law and monitoring mechanisms, human rights in Africa, with a particular focus on sexual and reproductive rights and women's rights. Dr. Nabane has substantial experience coordinating research, including systemic desk review and field research in multiple countries. Her work has been published in journals such as the Health and Human Rights Journal, International Journal of Gynecology and Obstetrics, African Disability Rights Yearbook, Constitutions of the World, and the yearly iConnect Center Global Review of Constitutional Law. The next panelist is Prof. Mark Epprecht, which I also hope I've pronounced well. If not, I apologize. Prof. Mark is a professor in the Department of Global Development Studies, cross-listed with history and cultural studies at Queen's University. He received his PhD in history from Delaware University. He is the 2006 winner of the Canadian Association of African Studies Joel Gregory Prize for his book, Hango Chani, The History of a Descent, Sexuality in Southern Africa. In 2009, he was runner-up for the Mel Herskovits Prize for his book, Heterosexual Africa. And the same year, he was awarded the Desmond Tutu Award for outstanding contributions to the study of sexuality in Africa. His research interests are in the area of social history in Southern Africa, especially the colonial era, gender and sexuality more broadly, especially cultural constructs of non-normative sexualities. And HIV/AIDS, environment and health, especially in urban context in South Africa, and as well as pedagogy for development, the politics of public history, culture, and human rights struggles, particularly around gender and sexuality, but also increasingly around the imperatives of transition to environmentally just societies in Africa and globally. And finally, the next panelist is Crispin C. Bande. Crispin is a human rights expert with interest in sexual and reproductive health. He is currently the executive director of the Center for the Advancement of Human Rights and Development. Crispin is also a researcher and LLD candidate at the University of Pretoria. He has previously served as the country director of IPA's country program in Malawi and has also served as the Deputy Director of Legal Services at the Malawi Human Rights Commission. So I think the bios of the panelists speak for themselves. We are definitely going to have a very, very interesting conversation. And we're really looking forward to the insights of our panelists. And we are very much more also looking at the engagement by participants today who are encouraged to continuously pop in comments, suggestions, thoughts and questions in the chat box as the speakers are speaking, and then we will definitely, hopefully, have time to engage with those questions and with all our speakers. So with that, I wish to give you a very warm welcome to this final session, and I will hand over to the facilitator, who will then hand over directly to our moderator. Thank you very much.
Thank you so much for that exciting opening remark. I think it really just encapsulates how we feel about having what is really such a timely and important conversation on all of the intersectionality that we've spoken to. I have the pleasure to introduce our moderator, who will be moderating the panel of Poverty and Transgressive Sexuality. What are the common connections of criminalization and discrimination? And so I have the great pleasure to hand over to Dr. Sitanang Nabene from the CHR, and we look forward to the moderation of this panel.
Sure. It's afternoon. Good afternoon, everybody. Sorry, it's good morning for me. Hi, everyone. And thank you both to ICJ and the Center for Human Rights for the invitation to moderate this important panel. It's a good thing that I'm just here just to call people's names. We do have the experts, which is our brilliant lineup of panelists that we have for this last session. And so just to reiterate the previous speakers, welcome again to everybody to the final panel as part of the Global South Symposium on SOGIE and Economic and Social and Cultural Rights that has been hosted yesterday and today by the ICJ and the Center for Human Rights. Obviously, we're the most important people, given that we're the last panel, but also a very important panel as well. Just to say, given that it is the intersectional panel that really brings together and tries to bridge the gap between issues around economic, social, and cultural rights, as well as SOGIE. As previously mentioned as well, so the panel also definitely within the past 2 days also seeks to build on the prior conversations that have been ongoing separately in most cases on sexuality as well as economic and social and cultural rights respectively. So this panel, the aim of this panel this panel really seeks to bring the conversation closer to home in terms of it being, as I said, an intersectional one that tries to bridge the gap between issues around sexual orientation, gender identity, as well as economic, social, and cultural rights. And so the panel is titled Poverty and Transgressive Sexuality in Africa. What are the common connections of criminalization and discrimination? As obviously we've been, the conversations have been ongoing for the past 2 days. There is obviously a close link and clear linkages between sexuality as well as ESCR, which are very clear. And we do know, and as I said, we do have the experts in the room who are going to talk about this, but we all are aware of the extent that, you know, an individual's access to an enjoyment of economic, social, and cultural rights has an impact on sexual rights, have an impact on their claims to sexual rights, as well as especially in terms of exploring and utilizing opportunities for privacy, freedom of expression, bodily autonomy, health rights, sexuality education, as well as mobilization and access to justice, which has been a key important theme for this symposium. So I'm not going to say a lot, as I said, the experts in the room. So at this point, I will want to welcome Professor Mark, who will set the context for us, particularly the economic and material underpinnings of resistance to SOGIE rights historically. Do we have Mark?
Mark has not joined us yet.
Oh,
so
okay.
I think that we can proceed with the other members of the panel, and we will come back to Mark.
Sure, that's fine. Thanks very much. So I'd like to welcome Ms. Aneka, who will say a lot of things about, broadly about criminalization and discrimination, but also about strategic litigation and the amazing work that she and Salk do as well. You're welcome, Anika. Please go ahead. Thanks.
Thank you, Sitang. Can you hear me properly?
Yes, we can.
Thank you. Cool. So thanks everyone for still being here in the afternoon on a Friday. No, it's not a Friday. It's a Tuesday. Okay, well then it's fine. Then it's good you're here, and I hope you're taking notes. I'm just joking. To be honest, I got a bit stumped when I got the title for the panel, and it says Transgressive Sex and Poverty, Connections Between Criminalization and Discrimination, which is a mouthful for anyone to handle at the end of the year. So I'm going to try to just briefly speak about some of my ideas around what some of those connections can be. And I'm very happy the topic is framed so broadly, because I think over the past few days, you would have discussed quite a bit about, or the past day and 2 days, you would have discussed quite a bit about SOGIE rights. But I think there's a broader discussion there about criminalization and transgressive sex, whatever one might see that to be, but to look at sexuality and how the criminal justice system and criminal laws are really used to discriminate against people who are transgressing stereotypes and gender norms, and then to also look at how those sort of forms of discrimination are not only limited to people based on their sexual orientation and gender identity, but it intersects with so many other forms of discrimination. I know I can see Dr. Eprich has joined us. I don't know, I was just about to start my presentation, Dr. Eprich. Do you want to start? Because I know you're supposed to go ahead of me.
Mark, you're on mute.
Yeah, sorry about that. And again, apologies for being late. I was having technical difficulties now resolved. So actually, Annika, why don't you go ahead, because I'm just a little bit flustered from all this computer stress. Sure.
I'll go ahead. Thanks, Mark. Yeah, so I want to give you, I know we've been speaking about SOGIE rights. What concerns me is how the criminal law in general is used in various ways, and not just criminal laws, but the criminal justice system, the police, how it is used constantly in various ways to target people who are perceived to be transgressing sexual boundaries, sexual norms, and those sort of things. Now, I want to give a few very recent examples, and these are examples of cases which are before the courts as strategic litigation cases or have been litigated on. I'm just going to give you 7 examples, so it's not too many, but to show you how we need to have discussions about criminal law and how the criminal law is used to subjugate people, is used to discriminate, and what we can do about that. So I want to start off. So there was recently a magistrate in Malawi who wrote a judgment about defilement. And he had acquitted an adult male who had defiled, or that's the term of the offense, a 15-year-old girl. And his reason for acquitting the man was because the 15-year-old girl has clearly had other sexual encounters, and therefore she is no longer, she doesn't have an immature vagina that needs the protection that the offense is supposed to offer. Another example would be one in Zimbabwe, where police officers arrested and stripped a transgender woman simply because she entered a bathroom designated for females. More recently, you can see, for example, and this is a case that's been grappled with in August by the Uganda courts, about the Anti-Pornography Act, which is ostensibly created to protect women, but which actually resulted in increased violence against women since it was enacted, because women were now being undressed by men in public places when they perceived those women to be indecently dressed. Another example, and there's been positive judgments from the Nigeria courts on this, is the practice in Nigeria where you have a joint task force of police, military, and then the Environmental Protection Board, which environmental has certain connotations, but they've sort of decided that environmental protection should also extend to cleaning the streets of sex workers or any women deemed to be sex workers. And in the course of doing that, they sexually harass women, they arrest them, and they violate a range of their rights. Another example would be where in many states in Africa, people are actually denied the right to freedom or the freedom to associate based on their sexual orientation or their occupation as a sex worker, simply because those might be subject to criminal laws. So they denied the right to associate, even if there is no criminal conduct or they haven't engaged in any criminal conduct. Two more examples. In Kenya, for example, there was a recent case where a person on the autism spectrum was arrested for public indecency after he undressed in public. And he was then taken by the police to a psychiatric hospital without trial, and he's been there for the past 6 years. And then lastly, and this is something which frequently happens, but in Malawi, where a magistrate sentenced a 16-year-old boy to 14 years imprisonment for consensual sex with a 16-year-old girl. Now, all of these are, I mentioned because when we look at criminal law, there is something to be said for why we have criminal laws and why we ought not to have them in many cases, and why they have, from colonial times until now, been consistently used in a way that overreaches to punish people who aren't deemed to be complying with gender norms. What we see in all these sort of cases is how criminal law is then used as a tool to discriminate. And its criminal law is allowed to be this tool for discrimination by being vague and by often not distinguishing between what's consensual and what's non-consensual acts, or what are acts which result in harm and acts from which no harm derive. A frequent issue, and this is something that the African court has recently dealt with, is how the criminal law also particularly targets people based on economic status. And the African court went as far, and it's quite novel in doing so, in actually including economic status as one of the prohibited grounds of discrimination, where it's not, often it's not about the offenses itself. It's about the fact that there's a policing culture which dates back from the colonial era, but it's very much alive today, that allows police to target anyone they see on the streets who they deem as poor or from a lower economic status, or who doesn't follow the police's perceptions of morality or gender norms. And they use the criminal laws, whatever those offenses might be, and it can be completely banal offenses like vagrancy or common nuisance, to specifically target people. So it's not just about criminalization, it's about how police criminalize in their actions and in how they enforce laws or use laws as a tool for discrimination. Am I still on time, Satang?
Could you perhaps wrap up in a minute or two so that we will be able to have the time? Thanks.
Sure, absolutely. So I just want to make 2 points about that in all these instances that I've mentioned, the courts have had to come in and be called on to come in to address the injustices. And the courts have been the only recourse in doing so, because in all these instances, it were people who were from minority or marginalized groups. And in a parliament that consists of a popular majority, parliaments are often not the place where people will be able to get justice. And that's why we need our courts to be there to protect and enforce rights. And when I come back, Setang, at the later stage, I'll speak specifically about how courts have gone very different ways in deciding whether or not to actually address such injustices in Africa. Thanks.
Great. Thank you so much, Aneka, for that brief but very comprehensive overview of the use of criminal law, as well as just generally in terms of the criminal justice system around the continent, especially regarding individuals that are considered transgressing in relation to sexuality and so forth. At this point, I would like to invite Prof. Mark, just 5 minutes to give a quick overview of the economic and material underpinnings of the resistance to SOGIE rights, especially from a historic perspective. You're welcome, Prof. Thanks.
Okay. Will the host let my face appear on screen? Okay, there we go. Yeah, howdy, everyone. So 5 minutes. Okay, so that's really tough. I'm a historian, so maybe I'll just try and give a bit of a deeper background. And it comes from, I guess the argument is often made that, these laws are put there to defend African culture. And that African culture is often assumed to be not just unchanging, but also somehow unconnected with the material world. It's a bunch of ideas. It's a bunch of practices inherited from the past. And there's some truth in that, but it also is connected to the political economy, and it does change over time. And I would just like to make the point that there is a tendency among us, scholars and legal experts sometimes to regard people's support for these atrocious laws and practices and abuses that we just heard about. And to say, the people who like this stuff, they have a kind of false consciousness, or they're trapped in some, pre-modern way of thinking. And that's a kind of, I understand that a lot. I'm probably guilty of it myself, but I see that's a problem. It's heard as a kind of elitism, and it feeds into the perception that advocating for these rights is coming from away. It's coming from either a class that doesn't speak to the majority population, or it's coming from actually away, that is the West. So it seems to me, and this is something, I don't know, I'm just throwing out there because it may not make sense to you all, but if we can listen and pay attention to the real economic and material concerns for poor people who see a logic behind the homophobic persecutions that isn't just culture, amorphously and unchanging. And I'll just give a couple of examples. So for example, go way, way, way back, pre-colonial times, and it's still there, attenuated, but the culture still values extended family. And but part of that is, of course, marry and have children. Children are an economic asset, not just, cuddly little humans. They contribute to the wealth of the family. So when a son opts out, if you could even imagine this, comes out as gay in the past, there's no such thing as that in the past, but someone to say, no, I'm not going to marry and have children, is a direct economic harm to the family, as well as a political harm, because the kinship, networks help in the survival of family and prosperity. So when you fast forward into the modern age, so for a daughter, say, to come out as a lesbian and say, no, I'm not going to marry, well, that's a double whammy, because now she's saying, I'm not going to marry. I'm not going to bring cattle into the family through lobola, right? And that's the direct blow, not just to her parents, but to her brothers, right? So there is this kind of fear that, if you let people out of these family obligations, it's going to be a hit and not just to the parents, but actually the siblings, male siblings in that case. So that's one thing that's kind of in the background there. I'm thinking too about the, you know, the colonial political economy, we'll say racial capitalism. It also introduced some, well, many, we'll say, social pathologies, and people knew about these things, and they weren't spoken about, but everyone knew about the mind marriages. Okay, massive male migration to the industrial centers where men took sexual partners, often young. And in the early days, it was literally boys until the state banned boys, literally boys, under 12 years old. It banned them from coming to the mines because of the danger, but also because of these sexual relationships, which today we would call pedophile, you know, and abusive. But at the time, it was a widespread practice, and that has nothing to do with homosexuality per se. But in the popular understanding, you know, the racial capitalist system, which was impoverishing the countryside and creating these conditions, was, you know, a desperate evil. And another component of this too, in the industrial system as it emerged, you had the emergence of criminal gangs and massive incarceration of people, where, again, this has nothing to do with homosexuality per se as a sexual orientation or gender identity, but a practice that was known and feared in the majority population. And so you had these criminal gangs, originally called the Ninevites, became the 28s, a whole bunch of numbers gangs, where homosexual rape was part of the initiation and the practice, the identity of these gangs, very, very fierce killer gangs. And so for people at the front lines of this kind of, you know, township life or on the margins, this idea of same male-male relationship was something to be actually feared, not just a kind of theoretical concept. And probably my time is coming up. I'll just mention one other thing that sometimes gets overlooked in this too, and who knows how far down this percolates into popular culture, but I think at the intellectual level around Africa, I've heard this many times, you know, coming from the West, you know, advocating SOGIE rights, right? This is the same group of people who advocated structural adjustment programs, right, that have impoverished millions and millions of people and dispossessed them from their land. So how can you listen to people who are advocating, on the one hand, all this raft of rights, and on the other hand, they're basically looting and creating the conditions on the ground that are making life harder for people? So there's a disconnect there that I think we need to be more respectful of in our sometimes our harsh condemnation of you know, African homophobia, quote unquote. So that's probably about 5 minutes, I'm thinking.
Thank you so much, Prof. Mike, for that quick historic context, and definitely I think we will. Thank you for taking that time. We will really have time to engage, especially with participants and everybody else that is listening and is part of this panel. Please do put in your questions if you have any in the chat, and we'll have time later on as well to ask direct questions as well. And just before we delve into questions and more open discussion, I would like to invite Crispin to, as somebody who has worked in different levels, both at the political level, but also in terms of engaging with strategic litigation, to help us connect the dots, especially given the context that, you know, the pattern of democracy that we see, especially in the continent, as well as elsewhere around the world, has been deteriorating, right? And in terms of democratic values, and, you know, and I think the big question is, perhaps an attempt to try to address this question is whether, you know, in light of this context, in light of the decline of democracy around the world, but most particularly in the African continent, how can we ensure and advance the realization of SOGIE and ESCR rights in the absence of democratic gains, in the absence of this particular context, especially in relation to the African continent? You're welcome, Crispin, and you have about 5 minutes. Thank you.
Okay, I'll try to discuss as much as I can within 5 minutes. So just as the introduction by Dr. Satang, the progress on the economic and social rights and the realization of rights under SOGIE has been problematic in Africa. You would realize that in most constitutions, especially in Southern Africa and Eastern Africa, you notice that probably it's Kenya and South Africa where economic and social rights are expressly provided in the constitution. But then when you go to the South African context, and in this case, if you look at the case of the Republic of South Africa versus Great Boom, which was the right to housing, the court itself, I think, explained clearly that it is important that economic and social rights need to be addressed. And then Article 43 in the Kenyan Constitution, which is specifically provide for issues of right to health, right to food, and so on. It is interesting that right now we don't have a clear judgment that has expressly stated the kind of steps that NGOs can work on to make sure that that article is properly enforced. Comparably to Zambia and Malawi, you'll notice that the economic and social rights are provided for under principles of national policy. Therefore, they're not expressly provided. But then you see that all these countries have signed the International Convention on Economic and Social Rights. Comparably, all these countries have signed the International Convention on Civil and Political Rights. But then when we go back to the point of how do we enforce the rights under SOGIE, it is problematic because right now in most of these countries, we still have criminalization of same-sex relationships. Probably comparably, we will notice that South Africa, which has made progress on issues of economic social rights, has also made progress on the issue of same-sex relationships. Now, the challenge that is there right now is that despite the fact that these the different African countries have got different constitutions, of course, but all of them have signed international instruments that promote and protect human rights. But the question is, what is it that has happened so far? So the progress is very slow, and even compare that to issues of poverty, you find the suffering the same because, I mean, in terms of statistics by World Bank, by World Food Program, the people are still suffering. They cannot even meet basic needs. So therefore, you can put in a context that even the basic needs or the basic rights of people under same-sex relationships can also be met. So the question is, what is the problem? So one of the areas that we usually talk about under an expert is the judiciary. Now, judiciaries in Africa have some have made progress, but still have got challenges. In the context of Malawi, yes, the judiciary is independent, has made progressive judgments. Recently, 2020, I think it was only second to Kenya to overturn an election where they ordered the new elections, and the new elections made a different president or central office, which was different in Kenya, but they maintained the president. But then we see that when the judiciary is making progress, the executive part of government becomes uncomfortable. Just as they become uncomfortable on issues of economic and social rights, they become uncomfortable on issues of same-sex relationships, they also become uncomfortable on the progressive judiciary. So, I mean, the struggle in Kenya is quite known on how the executive has been trying to put pressure on the judiciary, more or less trying to control the judiciary, and also in some cases not comply with the judgments. We have seen that problem in Uganda at the same time. And also in Uganda in terms of the democratic principles, because right now, would comfortably argue that the country is not as democratic as the citizens would expect. So that also is reflected in the performance of the judiciary. Zimbabwe is the same example, that the performance of the judiciary is not reflective on what the citizens expect. But you see that the slowness of the judiciary, or the limitation of the judiciary, has an implication on the realization of economic and social rights, and also realization of civil and political rights, especially same-sex relationships. And also, I think in Zambia, we saw the struggle with the judiciary during the time of President Lungu, whereby you saw we could see the executive also trying to influence the judiciary on progressive judgments. In the context of Malawi, yes, we may say that the judiciary has made progress, but then it has not made progress on issues of same-sex relationships, which fall under civil and political rights. These are issues of privacy, discrimination, and also on. Now, coming back to South Africa, when you look at the judicial and the progress made, there have been different moments occupied by different judges, because the previous progressive judgments of Makwanyane, Group case, treatment action campaign is also attributed to a particular era of judges. So the Africa right now is still struggling in terms of where do you get progress. The room is through the international mechanisms, international human rights accountability mechanisms. But also we've got a problem on how the domestication or the domestic application of international instruments is enforced in different countries. Because we see in certain countries at an appropriate time, they would apply the international instruments in a particular subject. But when it comes to same-sex relationships, you find that the judiciary is very slow. And also then the role of parliament, that in certain countries like in Malawi, you find the judges raising the flag that we need to domesticate some of these instruments. While in some cases they feel they are less controversial, they would easily utilize the international instruments, especially the famous cases where Madonna was allowed to adopt children. And then they use the principles of interest of the children, which are under the Convention of the Rights of a Child. And then also when you look at the international human rights accountability mechanisms, we have the Universal Periodic Review, we've got the Human Rights Committee. You find that the NGOs that submit shadow reports have been slow to confront countries specifically on progress made. The concerning part also is the diplomacy at international level, where under human rights, for example, the Universal Periodic Review under Human Rights Council, countries are very slow to condemn fellow countries in terms of the progress made. So what are made are simply recommendations, and then the burden is up to the state to accept the recommendation and reject the recommendation. So, I mean, in the context of human rights, there are so many pieces that are there that are slowing progress. One, in terms of how we can realize the rights of under SOGIE in the context of same-sex relationships, because the progress in Africa is very slow. Again, when we look at economic social rights, the countries are still, the majority of the people are still suffering from poverty. And then using the human rights instruments has been slow to make progress in terms of utilization of human rights instruments. And then you look at the democracies on how powerful the executive branches are in terms of influencing the judiciary, that has an impact on how the judiciary becomes independent and issues progressive judgments. So that all these things that we're grappling with in Africa, and also the failure by the international human rights accountability mechanism to be an alternative to the slow progress in Africa. So these are the things that we need to talk about, and this is just an introduction in the context of 5 minutes.
Thank you very much, Crispin, for that quick but very comprehensive response, addressing a lot of issues, and also very much also spotlighting country case studies as well in relation to issues around discrimination and criminalization within the context of what we're talking about. Just quickly, at this point, I will invite questions. I will read from the chat in relation to comments, but also would also like to invite Landilani to also share his question as well directly, if possible, instead of me reading, if you like. Please, I think in relation to that, you can raise your hand if you have a particular question. But whilst you're thinking, Portia did share that, and I will read it directly. Thanks for your points, Prof. Mark. Thanks for your points about economic factors which influence social decisions. Definitely well noted. About racial capitalism, noted also this current legal discourse, particularly within courts, perspective, same oppressive instruments, continue same oppressive systems. I am writing about classism in this regard. Thanks, Portia. In relation to Landilani's question, he stated that based on Anika and Prof. Mark's presentation, excuse me, how can we build an African criminology to address incorrect historic narratives that feed the present day use of criminal law and the criminal justice system against sexual and gender minorities? Whilst we're waiting for other questions, perhaps I would like to invite Prof. Mark to attempt to answer this question, but also welcome in Crispin as well as Anika if they have any question. And then we also have Tim who has a question, but we'll address that after this one. Thanks. Prof. Mark.
Great. Yeah, thanks. I'll go to Landilani's. I think that's a great question, because the fact is there are these incorrect popular discourses out there which have a foot in real world experience, that people are aware of these criminal gangs. They're aware, for example, there's an idea that at the mines and elsewhere, these male-male relationships had some muti attached to it, right? That's one way to get protection from a rockfall. All these kinds of, it's not supported by scientific evidence, and that feeds into the fear and suspicion and scapegoating. So how do you fight that with a queer criminology? Well, one way I would say is to tell stories and to humanize the people we're talking about, and I do believe that's happening. We see the Gay and Lesbian Memory in Action archive there in Johannesburg is fantastic. And I don't know if Crispin knows, there's a book called Queer Malawi, where young Malawians tell their stories. I don't know if it's available in Malawi, but it's part of this project by GALA, the Queer and Lesbian Memory in Action publishing house, to put out stories that humanize people. And I believe it is having an impact. And I'm going to end right here on a recent poll by the Gauteng City Regional Observatory, which is a think tank that monitors public opinion and whatever. And just a few weeks ago, they came out with a poll that showed a remarkable decline in hate as expressed in opinion against gays and lesbians in the last 10 years. It's quite striking, from the number of people who said they absolutely agree that violence was justified against homosexuals has gone down a lot. And the number of people who said that they don't care has gone up a lot. I don't know the exact numbers, but I can send the link if people are interested. So that's just one element. And this is maybe a negative way to put it, that the people who said they don't mind living next door to a homosexual, their fear of foreigners was now greater than their fear and loathing of homosexuals. So that's a kind of, I mean, it's a negative way, but it on this front, it's a bit of, it seems, sorry, anyways, I'm going to end on that, but just the point is that once the humanity of same-sex loving people gets into popular discourse, it gets harder and harder to sustain these kind of incorrect narratives. And then I believe, the judges and like we've seen in Botswana, they'll stand up because, they're talking about people, not about some feared, muti-seeking agent of Satan, right? They're people. And once that gets out there, I think the judges will step up to the plate. That's what, well, we see that. And not just judges, parliamentarians in Angola and Mozambique have also moved in that direction. So I take a bit of, maybe it's too optimistic, but I know people say it's slow. It is slow, but it's been slow in most places, come to think of it,
Thanks, Prof. Anika, do you want to quickly jump in before we go to Tim's question?
Yes, please. If I can follow up on the Prof. I think the Botswana example is a very pertinent one. And this was something that was debated by the Court of Appeal in Botswana, because in other courts in Africa where they've had to deal with this sort of issue, I think there's a reticence by judges to deal with issues that might be linked to popular morality or traditional practices or anything that they might feel might be controversial. And it's often linked to the issue of, will society disintegrate if I suddenly make a decision that has been so fundamental to our society on a provision that's very much part of our way of life. And the Botswana courts grappled with this, and they noted that after the High Court judgment, which decriminalized same-sex acts, there was no disintegration of society. So a lot of perceptions that people have about what will happen if I recognize people's rights is often just that, perceptions. And the other thing that the Botswana High Court judgment did, and this was part of our Afrobarometer study, which is one of those studies that Prof also referred to, is that there was a study done in perceptions immediately after the Botswana High Court judgment, and there was a 10% improvement in attitudes towards your homosexual neighbor compared to what they had been before. Now, this is not static and can be influenced by many other things and is country dependent and all of that, but it is very telling of how criminal laws influence societal discrimination, and how, if we want to at least start dealing with societal discrimination, we also need to remove those laws which criminalize and which allow further stigmatization and perpetuate certain stereotypes. And that fear that we have, if there's a proper constitutional analysis around why we need to remove those laws, and if we bolster that with the evidence showing the negative impact that these laws have on people in their daily lives, then I think people will realize that there's no point retaining this, and the world is not going to fall apart if we remove some of these criminal laws.
Thanks, Annika. Tim, do you want to go ahead with your question?
Yeah, so from the ICJ's perspective, we work in both of these areas in Africa, and we're wanting to work further and try and deal with the intersection of them. And really what occurs to me is that, you know, the criticism that's often leveled in the United States, for example, of LGBT activists, and especially early ones, is focusing on issues that are of more interest to, you know, very white and male LGBT persons. Now, I wonder what the panelists' comments are about whether or not this has happened in the African context, and whether or not, and I'm not talking about necessarily racially exclusively, or whether we've taken a different course. And then if we have taken a different course, why hasn't it reached to direct litigation or more direct litigation on economic, social, and cultural rights of LGBT persons? And I say this aware that decriminalization is obviously a form of economic and social rights litigation, because if one is decriminalized, then one can access social services potentially in a better way. But I'm sort of trying to think further and ask the panelists to think further on that topic.
Thank you very much, Tim. Perhaps we can start with Crispin this time around and circle back. Crispin?
Yes, so going back to the first question before I respond to the second question, I just want to mention that in a number of countries, literature from UNAIDS on same-sex relationships has been useful on designing programs under Global Fund. That we have seen that some progressive language has been reflected in national AIDS policy. But so far, I think not much litigation has been explored to see how those little gains in form of policy can be reflected in the court judgments. I'm yet to come across advocacy strategy where civil society have made use of local policies on the Global Fund programs on the LGBT, for example. So that's one area on how we can make progress in terms of the things that we have struggled about on issues of criminalization. And then the second question on how do we really deal with these things, whereby we see the progress of social progress on economic and social rights, and then we see in the decriminalization. So it goes back to the point on how academic institutions, in terms of research, that some research need to be explored, specifically on how each country can make use on little progress, and then that can result in major litigation. Because the challenge has been there, whereby what would call a full throttle demand from the court that criminal provisions should be set aside, which has been difficult in certain cases. Like in Malawi, there is an attempt to throw out cases by judges through procedural issues or technical issues without dealing with the main issues, because the judiciary is running away from dealing with the main issues. It is the same on issues of economic social rights, where we have seen judges trying to run away on trying to incorporate the international progress on issues of economic social rights to the domestic arena. So it would be important to maybe to try to strategize that quick gain on decolonization may not be a quick focus on an immediate focus, but try to see the kind of programs that are going on right now by NGOs and also the policies that are in place that can be utilized and maybe demanding a little from the court, and as along the way you can put the pieces together and achieve a bigger decolonization.
Thank you. Yeah, thank you very much, Crispin. Annika, do you want to quickly jump in?
Hi, yes. I think perhaps just follow up from Crispin. I think he's entirely correct that what has developed in many countries is, in addition to constitutional jurisprudence, has also been counter jurisprudence, which favors cases being kicked out because of standing, because of procedural issues, because of the interest people have in the case, and because of many, and the courts are also increasingly using very outdated doctrines around the presumption of constitutionality or the need for self-restraint and separation of powers and all those sort of things to try and avoid dealing with difficult issues. And what is needed is that we align what our constitutions provide and the rights that they protect with our practices within the courts. And there's a big discrepancy in that alignment in many countries.
Okay. Thanks, Annika. Prof, do you have something in response to that particular question before a final question to you all?
Yeah, just Tim, that's a great question on the perceived whiteness and maleness and bourgeois nature of activism. I think that's something that activists in South Africa dealt with in the 90s beginning, and in Zimbabwe, when I was there, Gays and Lesbians of Zimbabwe, that was founded by middle-class white people, but they went through a transformation process. That's now more than 25 years ago. And the very strong ethic is to embed this movement for SOGIE rights in other struggles for social justice. So it can't be seen to be standing alone, and it can't be seen to be benefiting from Western donor money to the detriment of other wider activisms. And I think my impression from what I know in the region anyways, is that people are seriously committed to that. And I can point to, for example, in KwaZulu-Natal, that's their number one priority, is to conduct research and support in the rural areas, which is swimming against the tide in a big way. So I think, yeah, the effort is there, but of course the pervasive presence of Western donor money introduces another dynamic of, to seek to professionalize these organizations. You create a division between your activist leadership and people on the ground, and that itself can be debilitating.
Thank you. Thanks, Prof. Do we have any other question, a hand that I might be missing? If not, I have the last question. We have about a few minutes to end this panel, which is very interesting, by the way, and quite short as well. My question to you, to all three of you, is in terms of, with all the challenges that you've spoken about, as well as with the context and everything that's happening, especially given the increased trend of having being acknowledging that there is intersectional discrimination, but also in relation to especially economic and social and cultural rights, as well as criminalization in relation to that, and the intersectionality and the linkages between, economic, social, and cultural rights, but also in terms of the rights of sexual minorities as well. What is your, in terms of proposals and going forward, what do you recommend, or where do you recommend advocates and practitioners go from here, especially in terms of addressing the challenges? And these can be specific. As I said, we don't have a lot of time, but in relation to that specifically, what strategies or methods or approaches do you think, you find most promising in terms of moving forward, especially in ensuring the full realization of the economic, social, and cultural rights of LGBTQ+ people? Anika, do we start with you this time around? Maybe perhaps a minute or two. I know that I'll soon get a signal that we're almost out of time. Yeah,
you guys,
that's a big question, but sorry.
Yes, it's a very big question. I probably lost you halfway. A very deep one. I want to make one point, I think. When we look at jurisprudence, and that's where I'm coming from, there are a number of overlaps in how courts try to avoid protecting the rights of marginalized groups and SOGIE rights, and how courts try to avoid implementing socioeconomic rights. And both of these techniques used by courts to avoid actually giving people rights and acknowledging people's rights is based on outdated perceptions of the role of the judiciary and what transformative constitutionalism should mean in practice. So my advice would be a lot more work with the judiciary on this.
Thank you. Crispin? You're on mute.
I think in a minute, I think my recommendation is academic assessments of different countries when the little gains that have been made that can be explored for larger gains. Right now, there are a number of cases that have been adjudicated in different countries, and the ANECES organization has also done a lot of work on the different subject matters to do with sexuality and in different countries. But it's important to localize or to try to zero in into different countries and see what are the little gains that have been made that can be utilized by NGOs and society organizations, but also, for further academic research, so that we're able to achieve what we're unable to achieve. Because in the context of looking at larger picture, there are little gains that we can focus on that can be as a source of learning process into the quest to achieve bigger gains. So I recommend an assessment, an academic assessment, academic research on different countries on how, on the kind of progress that I've made, little progress that I think can result into larger progress.
Thanks so much, Crispin. And Prof, you have the last words.
Yeah. Well, I'll just say I appreciated Annika mentioned the bump in, sorry, I'm getting blinded by the light here. The bump in opinion in favor of SOGIE rights after the Botswana ruling. So I'd say if one thing can be done, it would be for South Africa, and for this, you're doing it right here in this event right now, and your other work is to support the struggle for SOGIE rights continent-wide. And that undermines a very powerful argument that people will say, and I've heard this so many times whenever I go to countries outside of the region, you know, well, SOGIE rights belongs in South Africa and it's not really an African country, right? But the more so-called real African countries like Lesotho, Botswana, I think, that embrace this. It undermines that argument. So I'd say, you know, the solidarity region and continental wide is really a huge step forward.
Okay, thank you so much to all of our fantastic panelists. I do, and last words from me, especially in relation to this theme, which was more of an intersectional one that bridges and tries to bridge the gap between, you know, SOGIE as well as ESCR rights as well. I think comes on the backdrop of, you know, we have been witnessing in the continent as well as everywhere else around the world, you know, the unprecedented inequality as well as concentration of power. And I'm sure this conversation have been ongoing, but we also do know that this has been further exacerbated by the increase in the consequences of the COVID-19, which we continue to live in as well. But I do believe as well, especially the past 2 days also have shown that, you know, people, activists, practitioners have been doing so much in relation to defending and practicing human rights in different ways and in different means. And I do think, especially with this last panel and just as a conclusion to this global symposium, that there is definitely a need for increasing connection as well as building intersectional approaches and demand in relation to SOGIE as well as economic and social and cultural rights. I want to say again, thank you to all the panelists, and also thank you to both ICJ as well as the Center for Human Rights for the invitation to be part of this very timely symposium. At this point, I will hand it over back to Alma for the closing session. Thank you very much.
Thank you so much, Dr. Sitang, for moderating such an important panel. I think that just the theme over the past days, really, I love that we ended on the idea of how do we move forward. And I think so much has been said around the work that has to be done, not only in the judiciary, but also around structural inequalities and what gains that have been made that we don't reverse, but that we continue to make more gains, but also the idea that more solidarity, not only is it important, but that we need to continue with the solidarity, not only in the region, but on the continent as well. And I think that's such a beautiful way for us to really end the second session of the Global South Symposium on the intersections between SOGIE and ESCR. And now we'll hand over to Kanyo to make the closing remarks for what has really been a phenomenal symposium on the various intersections that we've spoken to earlier today.
Thanks so much, Alma. It will be my colleague, Timothy, this time. Over to you, Tim. Thank you so much.
Okay, so thanks everybody for coming and attending. I think that I just want to say some thank yous, and I'm also aware of the fact that we're going to miss people out when we do this. But firstly to Ayo and Michael and Onin, who I think are still here and have been here the whole time, who really were the people who did the organizing for this event over the last 2 days, which Kanyo and I otherwise wouldn't have had the time to give the dedication that would have produced these excellent results. Then to our facilitators, Alma and Letokonolo and Tiruna, thank you very much for assisting us in facilitation and on the social media side of things for the event. And then to the panelists for today and all of the speakers who came and gave their time at such a late stage of the year. It was a very packed schedule at this late stage of the year. We're very happy that we've got to put our time and our resources and also combine our efforts with such an excellent organization like the Center for Human Rights to try and think a way forward and try and assist in pushing the connections between existing areas of work within the ICJ and the Center for Human Rights to try and hopefully ensure the protection of all human rights, but especially economic and social rights of LGBT persons across the continent. I think that we've had a lot that we've learned. I think that if we will go and send around the recordings of the sessions that we have for all of you to disseminate, and hopefully next year we'll pick up again with our advocacy and see where we're going to go with that. There's some exciting research coming from the ICJ and the Center for Human Rights next year, no doubt, in relation to these developments, and you can rest assured that all of your contributions today have not only and yesterday have not only influenced the way that we think about things, but all of the viewers towards hopefully trying to make a bit more of a difference in 2022. So thank you everybody again for coming, and hopefully if you are having a holiday, which I hope that you will take at the end of this year, you will have a good holiday, and please feel free to be in touch with us on any of the email addresses that you have for us or on any of the social media links that you have. Thanks again. I think with that, we can close for today and for this two-day event.
All right, bye-bye.
Cheers. Thanks, colleagues.